Hello and welcome to Views from the Lake. I'm your host Alex Chalekian of Lake Avenue Financial. Well, now that tax season is behind us, the conversation with our clients shifts from tax planning to getting our financial estate in order. Consumer Reports recently did a write-up on estate planning traps and how to avoid them. As we have seen in recent years, some celebrity deaths have brought to light the problems your estate faces when you don't plan properly. Whether it means your estate's assets get tied up in the court systems for years or you pay more in federal estate taxes that could have been avoided by prudent planning. It's obvious that fewer and fewer Americans are prepared in this area. In fact, a study showed that only 54% of Americans that are 55 years or older had a will or trust in 2012. That number was down from 61% back in 1998. I thought this topic was very timely, so I wanted to share with you the 6 major estate planning traps and how to prevent them. Estate planning trap number 1 is putting everything in joint ownership. Many times after a divorce or the death of one parent, the surviving parent often adds a child's name or another relative to a property, bank, or brokerage account and other assets. They feel that this is a quick way to ensure that the beneficiary can take control if they need them to, and allow them to avoid probate and inherit the assets when you die. Most people fail to realize that the child or relative is now a full co-owner of the asset. You may not be worried about your child or another person you trust misusing the funds, but your assets will be at risk if he or she is involved in a lawsuit, bankruptcy, or divorce proceeding. You can avoid this trap by designating who will inherit your bank account, vehicle, and real estate automatically when you die. For example, you can set up payable on death bank accounts. All you need to do is fill out a simple form provided by the bank naming the person you want to inherit the account. While you're alive, the person you named has no right to the money. You can spend it, name a different beneficiary, or close the account. But at your death, the beneficiary receives the funds directly, thus avoiding probate. Trap number 2 is that you think you're too young or don't have enough assets for a will. A good estate plan can save your heirs some money. It can also protect you and your family while you are alive. If you don't have a plan and you become incapacitated, someone will have to go to court to be named your guardian so that he can make medical and financial decisions on your behalf. The process is not only unpleasant, but could also easily cost $10,000 or more. If other families object, the process could drag out. If you die without a plan, you'll have no control over who becomes the guardian of your minor child or who gets your assets. Don't assume that if you don't do anything, everything will go to a surviving spouse. Get a basic estate plan in place. You'll need a will which states who you want to inherit any property that does not have a designated beneficiary, and name a guardian to care for your young children. You'll also want to draw up a financial power of attorney, which will allow someone you name to make financial decisions for you when you no longer can. Healthcare directives allow someone to make medical decisions for you. You may also want to consider a trust, which will hold some or all of your assets and pass them directly to your heirs, helping to avoid probate. Trap number 3 is that you allow your legacy to be squandered. You may wish to leave property to a beneficiary, but worry that he won't spend it wisely or that she might get into trouble with creditors. Even if you respect your heirs' ability to handle money, they will be tempted to spend it quickly. In 2012, a study found that the average baby boomer had spent, donated, or lost roughly half of his or her inheritance in their first 12 months. If you are concerned, put the assets you want to pass on in a trust and include instructions on how and when it will be paid out. The trust will make payments to the beneficiary on a regular basis so they can't spend it all at once. Because the beneficiary cannot access the trust principal, neither can his creditors. Now, trap number 4 is that your current estate plan will cause issues among siblings. This is a big issue we see all the time. As soon as the parents die, fights between the siblings will begin. Any non-titled property such as jewelry, furniture, artwork, and who gets them is often the biggest source of problems among surviving family members. We recommend that you talk to your children while they're alive and find out what they want and expect. Of course, you'll make the ultimate decision, but at least you'll have the conversation with them so you can attach a separate list to your will that will break down how you want to distribute your possessions. This leads us to trap number 5, which is naming your children as a successor trustee of your living trust. Many times, this will also cause problems among siblings. This might not be an issue when you only have one child and they will be inheriting everything. But when you have 2 or more kids that will be splitting up the assets, it might cause them to turn on each other, especially if the living trust is vague on how assets are to be distributed. Now, your daughter might not want to sell the house and rent it out as income property, but your son might not agree and want to cash from the proceeds of the sale. An easy way to fix this is by having a separate trust company or a law firm take over as your successor trustee. This way you remove the kids from the equation and let the trust company or attorney be the one helping make the financial decisions that you wanted. Trap number 6 is that people forget what a will doesn't do. One of the biggest misconceptions is that a will has the final word. But if you have a 401k, an IRA, insurance policies, and other assets with named beneficiaries, that money will be distributed directly to the people named, even if your will states otherwise. So if your will says that you want your son to receive your life insurance proceeds, but your ex-wife is still the beneficiary on the record at the insurance company because you forgot to update your policy, guess what? She gets the money. Make a list of the assets with named beneficiaries and review them at least every 5 years. Make sure that all documents still reflect your desires. In addition, revisit your estate plan whenever there is a major life change such as birth, death, marriage, or divorce. To sum it up, these are the 6 major estate planning traps you need to avoid. If you're not sure if your estate plan runs into any of these pitfalls and want a complimentary review, please call or email us. We'd be more than happy to take a look at your current situation and give you some unbiased advice. Thank you for watching. We'd love to hear your comments. To watch some of our other videos and read our blog posts, please visit our website, lakeavfinancial.com. There you'll be able to subscribe to our weekly newsletter. You can also find us on Twitter, LinkedIn, and Facebook. And remember, here at Lake Avenue Financial, we manage your wealth with your goals in mind. Thank you for watching.